In today's episode of This Week in GRC History, we take a look at October 2019, the week CCPA was signed into law. Let's paint a picture. You're the state of California. You're the largest US state by GDP, and you'll be the fifth largest global economy if you secede. You're the home of Hollywood and Silicon Valley, and the largest tech companies in the world like Google, Apple, and Facebook consider you home. Recently, however, these tech companies have become increasingly troublesome. High-profile breaches like Cambridge Analytica and misuse of customer data has started to plague your borders. At a federal level, a fragmented approach to privacy regulation has allowed bad actors to repeatedly get away with little to no accountability. Something's got to give. And it does. All the way across the Atlantic, a small body of countries passes the most revolutionary privacy framework in a generation, GDPR. The immediate effect of GDPR is profound. Data privacy became commonplace conversation, and companies moved swiftly to avoid the law's fearsome fines, up to 4% of annual global revenue for violations. 2 years later, the state of California, eager not to be left behind, passed CCPA and brought a whole litany of GDPR-style protections to the American populace, all built around personal data. Personal data in CCPA includes, but is not limited to, real names, aliases, postal addresses, IP addresses, email addresses, social security numbers, driver's license numbers, license plate numbers, passport numbers, and so much more. So, what is CCPA? Well, the California Consumer Privacy Act empowers Californian citizens with the ability to 1. Know what personal data is being collected about them. 2. Know whether that personal data is sold and disclosed, and if so, to whom. 3. Say no to sale of their personal data. 4. Access their personal data by way of a simple request. 5. Delete any personal data about themselves that the company may hold. And 6. Not be discriminated against for exercising their privacy rights. The original bill came into being in 2018, and further substantive amendments were signed into law on October 11th, 2019. California wanted to make sure that as many people as possible were protected, and that meant it had to make sure as many companies as possible fell under the purview of the law, without, of course, burdening smaller companies. To that end, California set up 3 basic guidelines to determine eligibility. 1. A company that has gross revenues in excess of $25 million. 2. A company that buys, receives, or sells the personal information of 100,000 or more consumers or households. And 3. A company that earns more than half of its annual revenue from selling consumers' personal information. If you meet any of these 3 criteria, you fall under the ambit of CCPA. Furthermore, companies that meet this criteria, CCPA applies to them even if they are not physically present in California. As long as the company does business in the state and meets the requirements, CCPA applies to it. California may have been the first state to introduce a comprehensive privacy framework, but it definitely won't be the last.